There's a couple of rules I want to acquaint you with because we've never really spent much time on them before, and you wouldn't normally, but you will come across them and should be prepared to deal with them in practice as well. So the three rules that we're going to look at are Rules 66, 69, and 68. So they are coming at the end of the Rules of Civil Procedure, which means they almost come at the end of the civil case generally, but that's not always the case because some of these can sometimes be used earlier on in the process, and that would be Rule 66. Rule 66 talks about receivers, and we saw this in the Republic of Philippines case where they appointed a receiver and then changed it and called it a special master. But it is another extraordinary remedy that the court has the power to grant under Rule 66. And it says that the receiver can be appointed by the court to either be sued, be in essence the defendant, or to enter suit. And it is an extraordinary remedy, as they said in the Republic of Philippines case, because the receiver has all the powers to take control over that entity, to carry out court's orders, to satisfy judgments, and including the power to liquidate the corporation itself, if that's what was necessary in order to satisfy the judgment and whatever the orders of the court are. So Rule 66 is oftentimes only granted after there's been one judgment and another suit has been filed. It's such an extraordinary remedy. But it allows the court to appoint someone with the authority to take complete control over that corporation and to carry out the court's orders or to satisfy any judgments there are against that corporation, including the right to liquidate the corporation in its entirety in order to satisfy that outstanding judgment. So Rule 66 it'd be rare that the court would grant it. A lot of times in money judgment cases, we may bring a second suit on a judgment to seek the appointment of a receiver to take control over that corporation to satisfy that outstanding judgment. But, and so it's such an extraordinary remedy, you don't usually see it unless it's a post-judgment with a subsequent suit. But there may be situations where the court will appoint a receiver pre-judgment, but usually what we're looking to do is to appoint this entity, the receiver, and it's usually a lawyer, to carry out the court's orders. But it has extraordinary powers which the court will not authorize then a receiver lightly. Questions on the receiver under Rule 66? We'll take a look at them in order. Rule 68 is an offer of judgment. Now, Rule 68 is another interesting rule, and it's not used to the extent, in my opinion, it should be. But what Rule 68 allows the defendant to do is to make a formal offer of judgment. And if that offer, to in essence accept a judgment against you, and if that offer is not accepted within 10 days, I think it's 10, I just want to check it again now, 14 days, I'm sorry, then the offer is considered rejected. If that case goes to trial and the plaintiff receives less than what that offer was that the defendant made, then the plaintiff is required to pay the defendant's costs from the time that offer was made forward. And so what it does to some extent is shift the strategy of, do you really want to take this matter to trial with the risk that you could pay their costs? Now that cost won't include attorney's fees generally, but it will include cost of expert witnesses, the cost of subpoenaing witnesses to appear and the like. It can still be a fair amount of money. And then and you may be able to argue that there are some statutes that would confer attorney's fees, and then you'd have certainly a game changer. But what defendants should do, in my opinion, more often, especially where there are multiple defendants, is to use Rule 68 to really suggest to the plaintiff that this is a serious number and to assess your risk of going to trial and coming back with less than that number. Because even if the plaintiff is successful, but the number is less than the offer of judgment that that defendant offered, then the plaintiff owes that defendant their costs. And so especially when you get into a situation where you have questions about whether all of the defendants are equally culpable, why defendants don't use offers of judgment more often, such that the plaintiff actually have to make a hard decision potentially, is beyond me, because the defendant in essence has very little to lose. If we've talked about numbers and we've made an offer, and I don't think, well, you decide not to take it for whatever reason, the value in making an offer of judgment is now the plaintiff has to recognize that if that trial number, the jury's number, comes in at less than that, then you owe me my costs, and that can be still a pretty penny. And so what it changes the tables on a little bit is that the plaintiff has no risk in going to trial. Because if there was an offer of judgment, then you do have a risk of going to trial, because you even winning, you could still, if you recover less than that, you have to pay the other side's costs. So I don't understand why it's not made more often. The one thing you have to be careful about, though, is it's an offer of judgment. So in essence, you're saying, you know, I would concede that you can obtain a judgment against me for $25,000. And the court, if they accepted the offer of judgment because it's filed with the court, plaintiff accepts it, it then could be entered as a judgment. Usually when we settle cases, we don't want a judgment entered. What we want is a stipulation of dismissal under Rule 41. We want at least the record to indicate that this case was just dismissed. There's nothing else in the public record beyond that. And oftentimes it's accompanied with a confidential settlement agreement such that the terms can't be disclosed. On an offer of judgment, that's potentially there for the world to see. And the other big risk with it, when I saw it in Methuen, is if you're making an offer of judgment on a case where the plaintiff has brought that allows for the recovery of attorney's fees to the successful litigant, Civil Rights Action, 1983, stuff like that, then technically they've recovered judgment on an offer of judgment. The court can now assess attorney's fees, and in a lot of these cases, the attorney's fees can be far beyond what the plaintiff's damages actually are. In a lot of these cases, the attorney's fees become a stumbling block to trying to settle it. I had this one against big box retailer a few years back. Our damages were significant, but I contacted this other plaintiff who had a pretty good claim of discrimination, but their damages really were only $75,000 because she ultimately returned to work. They cleaned up their act a little bit, but the attorney's fees before we so $75,000 was probably likely what her damages were. The defendant would pay that, but they refused to pay the attorney's fees. The attorney's fees at that point in time when I was talking to them were about $275,000. So they said, well, we'll give you the 75, but we want to wipe out the other. Well, in a situation like this where you made an offer of judgment, if that judgment is entered, now we can then petition for an award of attorney's fees because we're the successful litigant. And so if the plaintiff's claims, if their legal arguments contain statutes that award attorney's fees, you can't really use an offer of judgment because it potentially exposes you to that attorney's fees claim. So that's what happened in Methuen. They said, I think it was a 1983 action, I think. And they said, okay, we'll accept the $250,000 offer of judgment. They did, judgment, and then they petitioned for an award of attorney's fees. And it seemed at the time that counsel representing Methuen wasn't aware that that would expose them by making that offer of judgment to an award of attorney's fees, my recollection it was they were seeking north of $1 million. Piece of protracted litigation. I think it involved the police chief. And they were saying, sure, give him $250, but we're going to now petition for an award of attorney's fees that was expensive. So you got to be careful using it under those circumstances. Because beyond that, frankly, a lot of times the defendant has nothing to lose to make a serious offer, and not just a serious offer of talking. It's a formal settlement offer. You actually you send it to the defendant in writing, and you can file it with the court such that they know there's been an offer of judgment made. So Rule 68, to me, is an underutilized rule by defendants, and that can be used more often to sort of turn the tables and make the plaintiff rethink whether it really makes sense to take that matter to trial. So it's a rule to think about as you get out there.
So
questions on that?
Yeah, I do.
Go ahead.
So the day up to trial, the day of trial.
You know, it says 10 days prior to trial.
14 days prior to trial.
It's 14 days prior to trial. I'll keep using the old number. 14.
So I've seen lawyers.
And the earlier you do it, the better. I'll explain that in a minute. Go ahead.
Okay. I was just going to say, because I've seen lawyers, they go up to trial, then they settle. So that's an informal.
Yeah, and that's the whole game of chicken that, you know, is just, it's silly, but there are a lot of lawyers that do it. It happened last semester. We had one that had gone on for probably about, no, we kept it pretty fast. So probably we're about 14 months in, had tried to engage with the defendant from the outset because there seemed to be numerous solutions, some of which involved lots of money, but there were other business solutions to it, and they would have none of it. We were set to start impaneling the jury on Thursday morning at 9 a.m. in Connecticut, and we finally settled that case at probably 6:45 in Andover that night, which it never had to wait till the end, but there are a lot of lawyers that really want to see, are you going to go through with it, are you going to try the case, you know, and thinking that brinksmanship the last minute, that they'll get a better deal, or I think that's what they think, or they may want assurances that you intend to try it, and I think that's it a lot of times. But, so those circumstances, we voluntarily agree to settle it, we file a stipulation dismissal, it's done. When this is properly used, it's used relatively early in the case, because it's only the costs and expenses that are incurred after the offer of judgment is made. So to the extent you do it early in the process, then there's going to be a lot more costs and expenses that occur later. The best example I could give you, I had one time, we were the plaintiffs, and there were 2 defendants involved in this, there were 3 car accidents. We sued 2 defendants. What happened, it's an odd set of circumstances. Those 2 defendants got into a car accident, maybe, I don't know, a couple hundred yards ahead of my person. The one that caused the accident, the one that caused the first accident, then went off the road. The car they hit then went into a bunch of 360s, ended up on my client's side of the road, and crushed her legs. So she was pretty seriously injured. Well, which one's responsible? The one that started, I mean, so we sued them both, obviously. Is it the first one who actually did set this whole thing in motion and likely, pretty much definitely caused the first accident by crossing into the other lane of traffic, going too fast? But even with that said, okay, so let's assume you stop the first one. Shouldn't the second person somehow be able to control their car within a few hundred yards? Because there's no doubt it was the second car in my client's lane of traffic that caused the collision. And so we were prepared to go to trial against both of them and let them fight it out. There was plenty of money available. And one of the defendants made the offer of judgment. And I actually don't remember whether it was the first one or the second one at this point. Whatever it was, they were going to say, wasn't our fault for this. We happen to be, wrong place, wrong time. Paul's graph, you guys still read that, I assume, type of argument that, not our fault. And that could have definitely been a case where you go to trial and you're not getting a joint and several verdict. You're going to get one or the other. So one of them made a offer of judgment, which was their policy, which was $50,000. $50,000 wasn't going to begin to cover what we were looking for in the case at all. And so then we had sort of a hard choice of, well, we've got one defendant left, then we've got to go to trial with, or at least we're going to stake the balance of the funds against. Which case do we think is stronger? And does it make sense to take the 50? Because there was a real chance that you could come back with a verdict. Not only could the verdict be less than 50, it could have been 0, because it was one of those where it's not clear that there's joint and several liability for that. And that was a great example of using an offer of judgment wisely, I think, because we had to sit down with the client and say, okay, listen, if you lose this, and there's absolutely a chance you're going to lose it, there's a chance you're going to lose every case you try. You got to be realistic, and you got to make sure they understand that. But in this case, it's more than just talk. There was a chance that the jury doesn't accept our version of it. They're going to find the other one likely completely culpable, because our person did nothing. So if we're honest about it, yeah, the verdict could be less than what this offer is, and if it is, you owe all their costs going forward. There were accident reconstruction experts in that case. There were more than a few witnesses that would have been produced and the like. The costs could have easily been 10 to 20 grand. Relatively young person, who the hell's got, anyone who's got 10 to 20 grand hanging around to pay the other side. So it was a conversation, we had to really have a discussion about what we thought was likely to take place, the possibilities that could take place, and was it going to hurt the case we had left against the defendant that we felt was more culpable, and certainly now we didn't have a choice but to make them more culpable if they were the only defendant left. To me, that was a very good example of using it, because it made us have some hard conversations with the client, but also require us to take a harder look at our case and see exactly what we think was likely to take place, because the jury could always do something different anyway. But that's a good example of using it early, where unfortunately, there's not a lot you can really do to avoid the point of Ray's point, which is there are far too often lawyers just want to play brinksmanship in a game of chicken to the very end. What I've done in that regard, and I've gotten yelled at for doing it, but I think it's fair. I think it's fair, is that it's hard to justify, but I think it's fair. Hard to justify to others, not hard to justify to yourself. I'll sometimes set a number, and I'll say, as we're close to the end, say 60 days to the end, when sometimes the final pretrial conference is. I've set the number, and I've said, and I mean it, and I've held it to it, that number goes up. Pick X number of dollars for every week thereafter. And then you can't be bullshitting around. You got to hold to that number, because otherwise people think you're just a liar. But so I've said precisely that. $750 for the next day, to the end of this week. After that, each week thereafter it goes up 50 grand. And here's my thinking. Okay, so if we're down to the last 8 weeks, then I'm going to have to do a lot more work in the next 8 weeks. I've done a lot already, but I'm going to probably lose at least 3 weeks, almost a full-time time, getting that case really ready for trial. Prepping witnesses, doing my motions in limine, finishing my instructions. The next 3 of the next 8 weeks are going to belong to this case. If I'm putting that much more time in and effort to succeed on this case, then there has to be a premium that you're going to have to pay. So the price for today is X, but for each week thereafter, it goes up 50 grand. Say. So, and to me, as I just rationalized it to you, I think that's a fair approach. Not everyone thinks that. I mean, the judges say, you can't go up. Well, why can't I go up? I mean, like this point is, and there is a theory of that. You can't go up from your initial demand, so you want to be careful. But again, if I have to work harder throughout, and I've got cases where the attorney's fees potentially are recoverable here, then the number does go up, depending on how much more work is put in. Most people don't accept it, even judges don't accept it. But I think that's a fair way to look at it. I'm not sure everyone takes you as meaning what you say, but that means then you just have to be prepared to carry it out and say, no, that number was last week, not this week. I stole it from this other lawyer who, Harold Cohen for Philadelphia, he had 4 defendants. He said, okay, listen, it's $1 million by Friday to get out. So he's talking to them, yada, yada, yada. I asked him if this was true years later, because this was the legend. And I said, and he said, and I guess, so the story always was the lawyer showed up Monday morning with a check for $1 million. He said no. He said, now the number's $2 million. I said that $1 million was till last Friday. He didn't show up with the number. And so I asked him about this story. And he said, and he's a real gentleman. He's not, bragging. He's a real real sort of completely out of time and place. We're in Savannah, and he's wearing a 3-piece gray flannel suit. The rest of us sweating our asses off. He's got a 3-piece flannel suit in Savannah with one of those old-time straw hats, they wear at the political conventions and stuff, one of those hard-brimmed ones. But anyway, I said, I got to ask you, is that true? True. He said, yes. He said, but it's not as bad as it sounds. He said there was a legitimate reason. He said he had 4 defendants. He gave them all the same offer. $1 million by this Friday. It goes up $2 million next week. And he says, and it's even worse than the story you've heard. He said, because the lawyer literally was crying, sobbing. He said, a grown man, crying, sobbing in his office, saying, you got to take this million, you got to take this check, you got to take this check. I told him, he said, I can't. He said, I told the client. He said, the lawyer, he's truly, and he's not like that. So, I mean, I 110% buy it. And I said, he said, I said, so it's true. He said, yeah, but it's true, but for a different reason. It is, but most people aren't aware of this. I made the same offer to 4 defendants. I saw them, it was an antitrust case, I saw them as joint and several liability. One of the defendants came in with $1 million on Friday. Well, now the price of poker goes up because there are fewer defendants left. He said, I couldn't take another $1 million. The number absolutely had to go up because I had fewer defendants left. And that's not uncommon in cases like antitrust or others where you have multiple defendants responsible. What we sometimes say is the first defendant gets out to finance the litigation. The second, so they pay the costs and all. In some of these cases, you're going to run $1 million in expenses. The second defendant gets out to make a little bit of profit. The third defendant will make it a lot because there's only now, let's assume it's 4. There's only now one other defendant left, so I got to make money here. If I don't, and the last defendant's left is going to be holding the bag. So if they don't choose to operate on that, with that understanding in that time frame, whoever chooses to take it all the way to the end could pay hundreds of millions of dollars in those cases. So I don't know what his numbers were at work there, but that's why he did it that way. Is the number does go up legitimately because the things change, and sometimes in those cases the first defendant not only gets out for money, but they get out because they give me all the documents that help prove the case against the other 3, making it stronger as well. So there's reasons why the number legitimately can go up, but most people receive that really badly. They don't understand how or why it should. It just sounds greedier. To me, it doesn't. I mean, the fact is I'm closer to trial I've now got more of what I think that I need to prove. Why it doesn't stay the same. You know, cases go like this, and numbers should go like this. It's just hard for people to sometimes see it that way, because partly what they think, it's second guessing. So I could have got out of this, we'll just pick an easy enough. I could have got out of this for $100,000 at the start, yep. But you didn't.
Right.
You know, that happened in the big box case. They could have got out for a lot less at first. But as discovery comes in, as things, you know, we get the case structured the way we want it, yeah, it's not the same number it was. You didn't want that number.
What if you had a judge who didn't like that representation? Couldn't you show them some statistical data that obviously the case is going to progress, numbers are going to progress?
No, they don't care. Judges don't care about statistical data. I mean, seriously, they want to get their way. Because when you say that, there was no statistical data would have changed this. You know, seriously, leans over the desk and pointing down at me like this. Okay. You know, the only thing standing between this case and the settlement. Yeah. True, but this isn't going to work. You know? Because really, that's our job, right? That's our job, is to take the judge's heat. That's what we have to do.
So Rule 68 appears to me as more of a defensive strategy than anything else.
It's not the plaintiff can't in essence formally offer to accept the judgment. It's the defendant's.
It has to offer.
Yep.
So with that being said, it seems to me that the defense could kind of hold back on some expenses, make this offer.
Oh, sure, and a lot of times they do.
Now,
they don't want to incur the expenses unless they absolutely have to.
Now, my question is...
And the other thing, hold on, just one other piece to add to that, because you're right. A lot of times, expert discovery follows regular discovery,
right.
And expert discovery is where it gets really expensive. So, yes.
Right, so that goes to my next question about the discovery end date.
Yep.
Wouldn't the discovery end date occur before there's a pre-trial conference to set a trial date?
Oh, yeah, yes. Discovery is well over before the final pretrial, not well over, but over before the final.
So you can still retain expert after the discovery end date has passed.
Fact discovery is passed.
Okay.
Because usually what they'll do these days is they stage discovery. So we do fact discovery first. When that's all assembled or fought over, then we go to the expert stage of discovery and exchange that information as well. Okay?
Yeah.
And it's expert discovery that becomes very expensive.
Right, because that's my thought, that they can hold back on their experts, make this offer,
well, but frankly, if you think about it, that's logical too, right? If I'm going to pay 10 to 20 to an expert, and let's say it's a relatively small case, and I've had this conversation a million times with different clients. The whole case is 50. It's going to cost us 20 just to get an expert, and half the time the jury is going to say they're paid anyway, so how much should we trust them? So if it's 50 to get rid of it, and I got to pay 20 for the expert, from a business standpoint, you ought to think about it anyway. So I'm going to push that to the back end anyway, if I can at all, because it's not a wise business choice. Again, why my number earlier is less than sometimes it's going to be.
Right.
It can be at the end. And again, it's a psychological problem for people. But if you think about, like you say, the logic behind it and the numbers, well, listen, that's before I invested 40 grand in this case. That's before we had all these expenses. And that's before we knew that the testimony would be as good as we now know, right? That's the thing. When you're making your settlement or you're trying to do it early, you don't know. You're hoping it'll be strong, but you don't know. And if it's strong, maybe it's even stronger than you thought. Well, why shouldn't the number go up? I've had cases. I had one case where they absolutely destroyed evidence. Absolutely. I could prove it. So you don't destroy stuff that helps you. And there's a presumption that evidence, even negligently destroyed, negligently lost in Massachusetts. There's a presumption in Massachusetts that it was harmful. It makes sense logically. And I could prove it unequivocally. It had been in a safe for most of the case, and then all of a sudden it disappears from the safe. It was that important that they kept it in the safe, and now all of a sudden it's gone. Oh yeah, and it's a personnel file. It's stuff that it wasn't just crap. It was stuff that would have been crucial to the case. So why, yeah, the number goes up. That's big. People know. So at any rate, that's that whole 68 process, but also gets us into some settlement issues as well. And then lastly, you've got one more rule number, which is Rule 69, which is the execution. And this is another thing that sometimes people don't have much of familiarity with, because this section is called attachments and post-judgment remedies. So we've got to start to think about, when we file suit, how are we going to know that there's money or assets available at the end of this process to satisfy these judgments? Because, and this is really important that you start to think about this if you're entering civil suits, is, you know, does this case make sense to put all this time into it? Whether we're getting paid hourly or on a contingent basis. If we're getting on a contingent basis, then we get a third of whatever we collect. But if, or 40%, or some lawyers even 50, or 25, depending on the case and the size. But if there's nothing to collect, 25% of 50% of zero is zero. And so you got to start to think about this, about finding assets and then preserving them while the case is pending, because case may take 18 months. The whole world can change in 18 months. You know, we at one point we had rented the 3rd floor to a company named Enron, who at one point was the fastest, biggest financial company in the world. They were going to build it out beautifully, and they were going to be up there for a year. And just like that, they were gone. There was one of the biggest financial frauds ever. And so you don't know. And you don't know if a company, if you're suing a company for big money, the likelihood is you're not the only one that's chasing. So you got to think about how are we going to satisfy any judgment. And even if you're being paid an hour, right? So you're going to make your money. If your client has spent $100 grand, $200 grand, or $300 grand, and then you're going to tell them at the end, yeah, well, thank you, but you're never going to recover any of your judgment. We were lucky, we were successful, we got you your judgment, it only cost you 350 grand, but here's a $1 million piece of paper that's absolutely worthless to you. Well, the likelihood is you're going to have a complaint at the BBO, because you should have told them that this was probably going to be a Pyrrhic victory at best, because there may not be any assets to satisfy that judgment. So what we do, and we're going to look at this in the first case, we think about, are there assets that we can try and obtain while the case is pending, by way of an attachment, like in the first case. And then if we don't have those, or even if we do have some of those things, what can we do post-judgment to be able to satisfy this execution? So Rule 69 talks about an execution in a money judgment case. And so you need to obtain the execution from the court and then decide what your other avenues will be here. One of which is, if you had an attachment on the real estate, you can take the execution, have the sheriff take the execution, as must be done timely, and then file that execution at the Registry of Deeds. It would then go, it dates back to your date of attachment, and you can either do what we call levy and suspend that execution, so you levy it against the property and then don't advertise it for sale, or pursuant to that execution and the attachment you've had, you can levy and sell the real estate. So you actually have the power to be able to force a sale of that real estate pursuant to that execution. So it's advertised in the paper and people come in and bid, and it's subject to whatever mortgages and liens were prior to your attachment or execution. But it oftentimes can result in a resolution to the case because people don't want to lose their real estate.
Right.
Sometimes it's underwater and they don't care. But the fact is, it's the principal means of being able to obtain some potential satisfaction to that judgment. Another part of this with that execution that people are oftentimes not aware of is Rule 69A2. It talks about obtaining discovery in aid of judgment or execution. The judgment creditor or a successor in interest whose interest appears of record may obtain discovery from any person, including the judgment debtor, as provided in these rules or by the procedure of the state where the court is located. What this means is this. I can actually take a deposition pursuant to Rule 69, now inquiring about assets, or insurance policies, bank accounts, or wages, anything that I potentially could go after to satisfy that judgment. All of those questions, how much money do you have, where are your assets located, where do you work and how much do you make, all of those aren't relevant
At that time.
at the earlier stage because you haven't obtained a judgment, so it doesn't matter. Once you've obtained the execution, you can then go into the same case, so I don't have to even file a new case, but I can try and pursue discovery from the defendant in aid of satisfying that judgment. So it's a rule that most people aren't familiar with, and hopefully you're able then to figure out where some of those assets may be and then bring suit on them or somehow try to seize them with the execution because now you know what assets the person actually has and the like, which you would not have been able to obtain from the defendant earlier, but you should have made that examination of public sources and the like to be able to try and figure out whether this case makes sense to go forward against. I've told you before, you probably don't remember it, when I was in Boston, we had someone come to us way after the fact. They had a judgment against a bad ladder company for, back at the time, so this had to be 35 years ago easy. They had $750,000. $750,000 35 years ago was a lot of money. But it was against a ladder manufacturing company. They made defective ladders. The poor guy broke his back or something, had horrible injuries, had a piece of paper that says he's owed $750. But as you might guess, a ladder company that manufactures bad ladders doesn't stay in business long. They ultimately went out of business. He's got a piece of paper that's absolutely worthless to them. And how it got to that point, I really don't know, because you should have investigated whether the ladder company had assets, first of all, and sought an attachment like we did in the first case here. You could have asked during the initial case if there were any insurance policies. That you're able to ask even before you obtain a judgment, what insurance may be available. But the fact is here is they fought the case throughout, so they put money into it. But you should have been thinking, well, what do they have? If they don't have insurance, are there things I should be grabbing now to just at least place attachments or liens on so that if we're successful at trial, the plaintiff's going to be paid? And the fact is that by the time we got it, there was really nothing we could do for him. We looked and looked. And because, again, you would have thought there would have been an insurance policy somewhere. But the fact is, at some point, you're uninsurable, too, if you're making bad ladders. The insurance companies don't hang around for bad risks either. And so there was nothing by the time the judgment had gotten to us. We felt bad, but there was really no recourse that the poor person had at that point. So they were seriously physically injured and had wasted a whole bunch of time in court when someone should have made a better investigation. It very well might have been legal malpractice in part there, but that wasn't something we were engaged in looked at. At that point, it was hard to trace it back. So that's Rule 69 on your executions. So questions again about that. Discovery and aid of judgment as a post-judgment remedy, and that happens under Rule 69. So let's look at attachments, because attachments are a means of preserving or holding assets while the case is pending. Because again, cases can easily take 18 months from beginning to end. And so we have to investigate the assets the defendant has at the outset to make sure that the case is worthwhile going forward, or to make sure that there are insurance policies that are in effect that are going to cover whatever the potential judgment is, or maybe we need to get injunctions prohibiting them from transferring assets during the course of the litigation. You got to think about the back end of the problem here, because it becomes a real problem if you haven't look to make sure and taken steps to ensure that there are assets available to satisfy a judgment. So this next case is a federal case. It's U.S. District Court here in Boston, and it's digital equipment against Curry Enterprises. And it has like a who's who of well-known criminal defense lawyers in here and civil lawyers as well. So if you look at the names on the list, Jeremiah T. O'Sullivan was the U.S. attorney with the Whitey Bulger case. Nancy Gertner became Judge Gertner. Reggie Quinlan, an interesting story. She was a former nun who became a lawyer representing the strip clubs in Boston. Yeah, there's a whole group of them. And Joe Valero was one of the best criminal defense lawyers around. His daughter, Julianne, now is representing Kevin Spacey down in the Vineyard. So there's a long tree there. And then there's Zalkind, Sheketov. What's interesting about it is most of these folks are criminal lawyers, and this is not, even though it talks about RICO, this is a civil suit. And what they're trying to do is get their protection for their assets, that what they think took place here. RICO, if you don't know, is a federal cause of action that plaintiffs can bring, provides attorney's fees and a multiplier for damages. And it's not all that complicated. What it really needs is just a couple of violations of federal law in order to be able to invoke RICO. And violations of federal law can be as simple as, wire fraud, mail fraud. These emissions cases deal with some of the basic acts that a lot of times you say, well, that constitutes RICO, because we tend to think of it's an organized crime type of prohibition, but its actual uses go well beyond that. At any rate, this digital equipment was suing the Currys because the Currys had stolen, as digital saw it, a lot of their property. And what they wanted to do was sue them to obtain the value of that property back. And so what they did is they sought a motion for a real estate attachment. The court granted the real estate attachment. When the court grants a real estate attachment, this is pre-judgment now, so a lot of times we file it as when the suit is filed, we seek it then. The court grants what's called a writ of attachment. That writ of attachment then is given to the sheriff. The sheriff goes, assuming it's non-registered land, the sheriff goes to the Registry of Deeds, files the writ of attachment at the Registry of Deeds, and it's there for the world to see. If it's registered land, and we talked about the difference between registered and non-registered land before, if it's registered land, the sheriff takes that writ of attachment to the land court, they file it at the land court, it's recorded with part of the title at that point, and again, the whole world can see. And what it says is that the court has authorized an attachment of that property up to a certain amount. And in this case, the court ordered an attachment, or they approved 4 writs of attachment. In this one, including an attachment in the amount of $3 million against property owned by Raymond Curry and Mary Curry, again, on 2 properties that the Currys owned out in Clinton, Massachusetts. And so the court authorized various attachments over the defendant's property. That's why there were multiple writs. So they have multiple pieces, and obviously in a case of this size and an attachment of this amount, it may take multiple properties to be able to satisfy it, and you don't necessarily know which one may have the best chance of either being sold or have the value in it. Now, a lot of this you could figure out, right? You can do a public record search. You can search at the Registry of Deeds. Now you can search in most Registry of Deeds from downstairs on the computer. So you can see where they might own property. You can see what mortgages there are. You can't get necessarily the value, but you can look at the assessment value, which is most towns, that's a public record. It'll give you some idea of whether there's value in the property such that it makes sense for an attachment. So some of that is simple legwork that you should be doing in order to make sure that this is a wise investment of your time. Because it's not about just proving liability and damages. It's about making sure that we can recover on the judgment so that it makes sense to be spending our time. But at any rate, so they got the attachments on the property, but the Currys then wanted to sell the property. Well, you can't sell that. No one's going to buy that property with that attachment on the property. What they want is clean title. So in order to give them clean title, you either have to dissolve the attachment or pay off the attachment. There's one other alternative, and they can, what we call bond over the attachment. Okay, they don't want to pay it. They feel that it's legitimately disputed or whatever. You can get an insurance company to provide a bond to the plaintiff for that amount. Which, again, from the plaintiff's perspective, I don't care how I get paid. I just want to know that at the end of this, I'm going to get paid. So what they brought is a motion to dissolve the attachment. They wanted an expedited hearing because the property was for sale. They didn't want to have the buyer run away. What they ultimately did is they stipulated that the defendants could sell the Green Street property to Weetabix and place 2 checks in the amount of $1.2 million and another $23 million in escrow as prejudgment security for the plaintiff. So in essence, instead of getting a bond company, and people have done this and people do this, say, okay, listen, we'll place $1.5 million in an account under the court's control in essence. So if we lose, they can just have the $1.5 million. Again, what we're looking at from our standpoint this week is post-judgment remedies. I just want some security for the payment of this judgment in the event we're successful. I expect to be successful. I want to know I'm not going to be chasing it between now and forever and come up empty. So I don't care what the security is. They must think, by the way, because to reduce from $3 million to $1.2 million, there probably isn't any more equity in the property. Because I would, if I thought I have a likelihood of a judgment of $3 million and I have a $3 million attachment, I'm not giving you a 1.8 to go play and do whatever you want with, or even more importantly, to be 1.8 to pay your lawyers to fight me even more. I'd just as soon have the attachment or put the whole $3 million in. So the likelihood is what they were going to do is take the proceeds and place it into this bank account under the court's control in lieu of the attachment. And so in order, I would think, for the plaintiffs to agree to that, that's all the equity there was in that property. So it's a good deal for the plaintiffs because they have some protection, and it gives the defendant the chance to complete the deal. Otherwise, they might lose this buyer. So the question is, the question is with respect to the attachment in the first case. How do you get the attachment? What rules govern the issuance of an attachment? This just happens to be for a whole bunch of money. But we seek attachments in a lot of cases, and oftentimes for a lot less money, because what we're looking for is security for the payment of that judgment. So, a couple things. Rule 64, it says, governs the procedure for a prejudgment remedy of a detachment. The rule provides the pertinent part, yada, yada, yada. Rule 64, the mass law controlling the procedure for motions for attachment, is found in Rule 4.1. So it says, look to the local rules, or the Massachusetts rules, not the local rules. And it says that all you have to do in order to obtain an attachment of real property is you must find that there is an existence of a reasonable likelihood that the plaintiff will recover judgment in an amount equal to or greater than the amount of the attachment, over and above any insurance policy shown to exist. So one thing when I'm seeking an attachment, and this is what it helps to do as well, is it flushes out whether there's an insurance policy. Because one way you can defeat it is to say, they don't need the attachment, Your Honor. We have $1 million policy. There's no chance that they're going to recover in excess of $1 million here. So I'll force their hand at least to disclose what the policy is and that the policy covers the risk. I just want to know that there's protection down the road. So one thing is, it's going to flush that out. We've got to think about that. And a lot of times they're gonna try to conceal what the policy limits are, because they know when you know that's the limits, that's what you want, okay? So the reasonable likelihood that the plaintiff will prevail in an amount in excess of whatever insurance is available. That's the standing. Not, I gotta show that beyond, I'm gonna recover beyond a reasonable doubt, just that there's a reasonable chance I'll recover over and above any insurance policy shown to exist. The standard's relatively low, okay? If I don't, but again, and that's it. It's not an injunction, it's not a five-part test. If I can't show a reasonable likelihood of success of recovering that judgment, then why do I need any protection anyway? And if they can show that there is a policy that's gonna likely cover everything I'm seeking, then again, I don't need this prejudgment protection, and that's what it is, okay? So what they're talking about is what the standard is, and then that motion should be supported by affidavits, as it says. I want to mention this again as well here, because it's a footnote 2, and I've said this before to you, but it says, without elaboration and without providing this court with a memo in support as required under LR 7.1A1. However, the current defendants state they have a good defense to this action. In federal courts, not only use this rule book, which is called the Federal Rules of Civil Procedure, but that every federal court has its own local rules, okay? And so you use this, but you also have to look up. I got a case now in federal court in Boston, and I've got to pull them down again, what the local rules are. Because if you don't comply with the local rules, you might as well not bother filing a piece of paper. They're not going to docket it, they may return it. For instance, a couple things I know are in the local rules. Everything now in Massachusetts in federal court is filed electronically. Everything. Good news is you can find everything relatively easily online. Bad news is you better be able to do some perfunctory things online, because it's not a paper court really for all intents and purposes anymore. Another thing covered by the local rules is that any discovery dispute, before you file that motion in court to compel or to have anything resolved with respect to discovery, the local rules require you confer with each other, to talk specifically about the problem, and then when you file that motion, you have to say when that conference took place, who was present, what issues you resolved, and what issues you left unresolved and need the courts to address. If you do not file that certificate with your papers, don't even bother filing it. So local rules govern specific, you could call them housekeeping matters with respect to filing motions and hearing disputes in federal court, but sometimes they go beyond that. They'll deal with the size of the briefs, the size of the fonts in briefs. You need to know that there are local rules in every federal court and that they have to be complied with. I had a really good Civ Pro teacher, and I'll never forget when we were admitted in federal court, Judge Wolf asked us, that's who this case is before, who asked us, well, how many of you know that the federal court is local rules? She never even talked about it. And she practices a lot in federal court. Just recognize this isn't the only body of rules that we have, that you have local rules, and that's what this makes reference to, is that if they were pursuing this motion by way of local rule, with all these lawyers involved, you would have thought one of them would have looked at the rule. They should have supported it with a memorandum of law with respect to the given authorities, and they didn't do that for some reason. And the court just didn't automatically send it back. I think this was an earlier point in time. These days, you're not even likely to be heard. But at any rate, they would like to, they still want to argue that they shouldn't have to worry about this attachment at all, even though the plaintiff has likely satisfied that standard that they have a reasonable likelihood of recovering a judgment over and above whatever insurance is available. And I don't think this is the type of case that there would be insurance available. At any rate, they have a recitation of facts here. Curry was engaged to destroy DEC's equipment, and instead of destroying it, they decided to profit by it, and so they sold a lot of the stuff that were making money on the secondary market, which in essence was undercutting DEC's profit that they would have made otherwise. And so they're sued under the RICO Act, Lanham, and a number of various state law claims, including, if you just think about it, a straight breach of contract claim. But it goes into a little bit of RICO and the like, which hopefully you looked at carefully, because RICO does not involve a lot of difficulty in a lot of cases. Establishing those two predicate criminal acts, even in civil cases. If you think about the the amount of emails and the amount of exchanges electronically that people engage in, that there's likely going to be some fraudulent activity there, or some use of those elements to be able to support a couple of criminal violations that would allow us to invoke RICO as well. And that's what happens here. And this one, obviously, is a lot more of a criminal element than just sort of routine business fraud that's involved in a lot of cases. So how does Digital fare with respect to their request for keeping their attachment and holding those funds? As you can see from on page 25, these properties were worth quite a bit at one point. They were unencumbered, it talks about it at the top of page 25, and they might be worth as much as their $3 million. Even though the real estate market had declined at one point, these property was purchased for $1.1 million, and at one point could have been worth well around $3 million as well. And so, as much as they might like to complain about DEC not being able to establish the value here, but when you look at the plaintiff would be entitled to get triple damages and the loss for their business property as well, plus attorney's fees, you could easily get to the $3 million amount and not be unreasonable or excessive. And so the amount isn't really going to be questioned. They go in a little bit to the due process argument about, is this fair to allow a prejudgment attachment of this real estate on without or until the Currys have been found to be responsible to DEC for this potential $3 million judgment. And it talks to us in this Roman numeral 4 of the decision, some pretty straight language about what the standard for an attachment is, which is very, very simple, right? The reasonable likelihood of success of obtaining a judgment in excess of any insurance shown to be available. There's going to be, this is not a situation where they likely have any insurance to cover their theft and fraud. And so the fact is, what is DEC reasonably likely to recover in this case for a judgment? And the court already looked at, they don't find that the $3 million amount is unreasonable at all. They weren't seeking an attachment ex parte, and that's important to understand as well, is that there are circumstances where even without notice to the other side, as they did in Dorr, Connecticut versus Dorr, that I could seek a court-ordered attachment without providing that notice required of the due process, but I would have to show that the defendant was going to transfer, encumber, destroy, or conceal the property in the event they were notified. If you can't show that, then you don't get to avoid due process, right? The defendant has a right and an opportunity, should have an opportunity for notice and to be heard. And only in extreme cases, such that if we could show they were going to sell the property that afternoon, or to transfer, hide, or conceal, or destroy it, then we could go in on an emergency motion ex parte without notice to the other side and try to get the court's authority then to do that, to obtain that without notice. There's also the notion that Dorr in Connecticut talked about, well, there should be a bond filed by the plaintiff in case that it's wrong. Well, that's only in the situation where it's an ex parte attempted attachment without notice. The fact is here, the court reasons through what the likelihood of success is here, finds no insurance available, and decides that it would be proper to issue that attachment against the real estate. An attachment against real estate doesn't dispossess the defendant at all, right? Doesn't say that you don't have the ability to occupy it. The only thing, and it doesn't even say you can't mortgage it. As a practical matter, you're not likely to be able to find someone to give you a mortgage with that attachment in place. But if you can, that's up to you. The likelihood, all it does is hold the plaintiff's place in line on that property while the case is pending. First in time, first in line. So if there are creditors or mortgages that come subsequent to that, well, they take subject to my attachment. If I'm not successful at trial, that attachment would be wiped out because it only was a placeholder, right? And so there really is no true deprivation of rights by way of a real estate attachment. The way we attach personal property, there would be. If I want to attach your motor vehicle, the way I attach it is I seize it.
Right.
If I want to attach your wages, the way I attach your wages is to take it. The sheriff comes down each week and takes the money. So personal property is much different. We had to seize a ship one time on a big judgment for payment. And the argument would be, well, the way they have to do it is seize it. This isn't a boat, this is a ship. So in essence, the marshals would have had to cordon it off, stay there, so it prohibited from moving. And a locomotive one time as well. So personal property is much more problematic. Real estate is not difficult to execute that attachment against. It's relatively minor cost for the protection it provides. At any rate, there was the opportunity by these folks to be heard. They satisfied due process. The fact is, there's nothing wrong with this attachment under the circumstances. They are, in fact, the court was correct that attachment should have been granted. I'm going to stop here on next class and ask you to fill out these evaluations. Next class, we are going to talk about the last case in the sequence to